Thanks very much, Kevin. It's Don Boyd here. Pleased to be here this morning. First slide that we're going to be going over is the learning intentions. This webinar is designed for beginning and also seasoned administrators, and hopefully will bring some things to the forefront. So you're going to learn about the responsibilities inherent in your new role as a principal vice principal, some key components of the personal services contract, and one of the key things is what to look for before signing a new contract.
Okay, it's Warren Hicks here. Good morning, everyone. So the good news is that you've become a principal or a vice principal, and what we need to talk about here a little bit is so changes your responsibilities and the expectations that the board have of you as you become essentially the agent of the board. So there's no, at that particular point in time, once you fall into this kind of an employment relationship, you're no longer ever really off duty. Public behavior can affect your position, and you have a fiduciary responsibility at that point as the agent of the board to carry out their initiatives and the provincial mandate of the Ministry of Education. So with a higher level of responsibility comes expectations. Back to Don.
Yes, thanks, Warren. So we talk about what guides and directs you. So you take a look, we have the School Act, Regulation 5 and 6, which outlines the duties and powers of being a principal or vice principal. It's the only section in the School Act that identifies powers. All the others have duties. You don't need to know everything, but you need to know where to find it. So we have the Teacher Regulation Branch Standards, which there are 8 of them, and they are for teachers and principals. We're bound by the same regulations there. We have our BCPVPA Leadership Standards, which are going through the 3rd revision now. We also have a Code of Professional Practice. Board policy also directs you. So if you can't find it in your contract, you may be bound by something in board policy. The collective agreements, CUPE and teachers, you'll find that teachers and CUPE don't know their contracts as well as what you do, and members will be coming to you asking for advice. Then you have your personal services contract that does outline specifics regarding your position, your compensation. Now, there are other things. You don't necessarily need to know it all, but you need to know where to look for it, or you need to connect with us and we can give some guidance and direction to you.
Okay, and the idea of connecting with us is an important one to keep in mind through this whole, through your whole career and your work. We're here to help you out. We'll get back to you as quick as we can, and hopefully be of a lot of help to you. Now, personal services contract, you move out of, when you become a principal or vice principal, you move out of your relationship where you were represented by the union. And at that particular point in time, the union has the power under legislation to be the spokesperson for you. So that's what the word, that's why they talk about it as a collective agreement, because the union is representing you. But in this particular case, when you become a principal or a vice principal, you come under a separate contract, a personal services contract, and that contract is between you and your employer. And as Dawn has pointed out, there's, as you scan through the offer of your contract, whatever your language is in your contract, you may find some, you may be thinking to yourself, well, I don't seem to see whatever it is you're looking for. And usually that's because some of those items come under a personal services contract and others come under policy of the board, with the difference being that if it comes under the policy of the board can change that language at their whim. If you're under a personal services contract, which you all are if you're a principal or vice principal, that's a negotiated item and cannot be removed by one party.
Thanks, Warren. So why is it not? No, okay, so key components. We're going to focus on 3 components of your personal services contract. There are many, and this is just a brief overview. This isn't everything you need to know about contracts. It's sort of an overview. So we're looking at terms and conditions of your employment as outlined in your contract. So the way in is what we refer to. Then assignment and reassignment, and there's certain specifics there that we would look for in your contract. And the other is termination. Now, most people don't want to think about that, but we will cover some key elements of that once you get into administration. So other items that are in your contract, benefits. Benefits makes up 21 to 25% of your overall value of your contract. But we're not going to be getting into that. Also holidays, professional development, sick days, short-term disability, long-term disability, self-funded leaves, and others. But we're just going to focus on the three that we have on the slide deck now.
So the way in, how do you get in to the contract? Or how do you get your contract signed up and get going? Most people, or at least a sizable percentage of our members, tend to be really excited about their the new contract offer they've got as a principal or a vice principal, and there's a tendency to just simply want to sign that contract without really knowing what's inside it. That's not a wise route to go, and we're recommending that before you sign a contract, you make sure that you understand it. Radical, I know. But anyway, our membership, we have leadership in every one of our chapters who will sit down with you happily and go over the contract with you and help you with any questions you may have. Same with us down here. If you have some specific questions, we'll help you as well. But remember, this is a contract between you and the board, and it's important that you understand what's in that contract. So ensure you've read it yourself and have had someone go over it with you. There's often people from the Human Resources Department of the district that'll do that as well. And I've already spoken about how it's different from a collective agreement, because now you're entering under an employment contract directly with the board. So before you sign, best to ask questions. So what should you look for while you're doing that? Is your contract, here's a few things to think of. Is your contract continuing or term? And if so, what are the dates associated with that in the contract? Does it lay out the amount of teaching and administrative time you have? Now, usually that is not laid out in contract, but districts tend to have their own ways of their own areas of operation and means of operation that can greatly adjust how much time you actually have from the administrative point of view to do the work. And it's important to know what the expectation is there as well. And is your contract specific to your position? We prefer to see contracts that use the word either principal or vice principal, depending on where you've been appointed. If you've been appointed as a vice principal, we would expect you to have a contract that would talk about being appointed as a vice principal, and the same with a principal. But many contracts across the province have a language that says principal / vice principal, and all through the contract it talks about that. And it's not that that's the end of the world, but what that does is it opens the door for the board to be able to move you from a principalship, for example, back to a vice principalship at their whim. So approximately 70% of the districts in the province have continuing contracts right now. But if you are looking at terms associated with the initiation of your contract with the board, give us a call and we'll help you with what it all means, okay?
So what Warren's referring to there is, on your initial placement, you might have a 2-year term specific contract. What we would ask for is that what is the process by which you can go from that term into a continuing position? Okay,
Right.
Warren.
So other questions you may wish to consider before you sign on to your contract. What type of mentoring or support do they have for you as you enter into this relationship with the school district? Do you know what your benefits are? And we're going to be doing more and more work and have been already, but we'll be continuing to work towards improvement of benefits for administrators through your association here. And considerations for sick leave, for example. You can port 60 days from your previous district's sick bank, but sometimes there's reciprocal agreements and so on in place. And once again, we can help you with that if that's the case. The other thing to be aware of is tied to long-term disability. And that is that there is a 120-day wait period if you had to go off onto disability. And the way the system works is your sick leave gets used up day by day until you get to the 120, at which point in time you qualify for long-term disability. If for some reason you don't have 120 sick days, then the question becomes, how do you bridge from however many days you have to that LTD date? Now, some districts have it right in contract. They just say, you're a principal, or vice principal, you're an administrator in our district, we're going to make sure we look after you, and no matter what happens, we'll carry you to 120. Then there's a group of school districts that have a short-term plan, and you'll notice that LTD and the short-term plans are paid for by yourself, and that's done so that if, heaven forbid, you have to draw an LTD for a portion of time, it's a non-taxable benefit. If the board was to be paying for that, it's taxable, and it has quite an impact on the bottom line as to what our members would see. So if you haven't got it in contract, most districts have a short-term disability plan, and that's that's an extra little bit of payment that you have to make on a monthly basis, but that then bridges you through to LTD. And then there's about 8 districts or so that have no language whatsoever. And so if there's a shortfall going to LTD, there has to be some negotiation that happens around that. So understanding these kinds of things is important, and we're not here to go over the whole contract today, but these are the points of clarification that our members in the chapters and ourselves can help you with.
Yeah, Warren, thank you. One of the key things with regards to your sick days, a lot of members have gone to a different district and they haven't inquired about that, and the districts don't volunteer that right up front. They might front end load you the 18 days that you get, but some districts only give you 15 because they give you 1.5 days per month. Well, you're 12-month employees. You should be getting a minimum of 18, but you need to ask. You need to know the right questions to ask so that you're not left out. One of the other things is that all teachers have short-term disability. Even if they only have 5 sick days and they're new teachers and they go off, they have short-term disability plans, and we're working towards that provincially right now. Assignment, reassignment. Well, what we're looking for is fair and reasonable comes to mind when talking about assignment and reassignment. So you're hired as a principal, you've moved districts, you go to another district, and they reassign you to a VP position. And we're going, what's fair and reasonable? And we would work on your behalf. We want to ensure that there's a clearly defined process. And the process would provide notice period. It would provide a rationale in writing. It would allow you an opportunity to meet with your employer. Now, your employer is not the superintendent, assistant superintendent. The employer is the board. And so if you're going through a reassignment, you need to see and make sure that that is in your contract. Otherwise, we would say the process is not necessarily fair. The other thing is mutually agreed to is a key word that we like to have in the contracts. A lot of people, when they move in, they don't look at the reassignment assignment clause. As Warren said earlier, they're just happy to get a contract and sign it off. However, there are some members that have been in a position for a year and they have not seen their contracts yet. the district saying, oh, well, you know, we're revising it, etc. You need to have that contract signed going in. So look at this. Do you have wording that reflects changes that are mutually agreed to? I mentioned that. But one of the other things is red circling. Red circling means that your salary remains the same for a period of time after reassignment. So if you're going from a large school as a vice principal and you move to a smaller school and the salary is less, then you would be red circled at that higher level. Now, I know we have a new grid in place, but there are a number of districts that still have school size as a determining factor as to what your salary is. It should be noted that the district does have managerial rights to reassign. Okay, it's within their management rights. However, that being said, we need to have fair and reasonable process in place for our members. Now we get into termination. Well, nobody really signs up to be a principal, vice principal with the idea that they're going to be terminated. But one big difference is when you're in the teachers union, the only way you can be terminated is with cause. And with cause means you've done a criminal act or harm to kids, etc., along those lines. When you move into administration as a principal or vice principal, you can be terminated without cause. And that means that maybe the district's going in a different direction. Now, you're hired for your decision making and judgment. And maybe after a period of time, the district goes, you know what, Don? We're going a different direction. We hired you for your judgment, but you're not making sound decisions, so we're going to terminate you without cause. Wow. Well, what does that mean? Well, it means that the School Act will protect you, and Warren's going to talk about that in a little bit. But there are different types of termination. So you have with cause, which is criminal intent, without cause. You also have by mutual agreement that maybe it's not the best fit, and you say, okay, and the district and you agree. The other one is through retirement. You give your notice and follow the deadlines. There are certain requirements that you have, notice periods. If you're going to resign or go somewhere, a lot of them have 3 months that you need to follow those timelines. Who decides on termination? Well, basically it's the district and the board. They have that managerial right again to terminate without cause. Now, one of the things when the termination date, some contracts start July 1st, the vast majority in the province start August 1st. When people have been terminated without cause or moved to another district and their contract date is July 1st, we have found some problems about bridging to another district, that sometimes employees, principals and vice principals are left 1 month without pay by either district. So be wary of what contract date you're signing your contract on. Termination choices talked about porting of seniority. So if you're a principal or vice principal, you've worked in the district for 6 years, for all intents and purposes, those 6 years count towards seniority when you get your teaching position. So if you were a teacher in the district for 3 years, you went into administration, you were in there for 6 years, you now have 9 years of seniority. The other is salary continuance and benefits, but again, we're not going to cover all of this. It's information that we'll cover up in other webinars. Warren.
So back to the importance of language in the contract, as Dawn has laid out for you. These are some of the aspects of contract that we would be looking for wording on, and we have this pretty much provincially. Is that if you're going through a process of termination, that you have the opportunity to meet with your employer, to meet with the board, and you're advised of the reasons for the contemplated action, and that you have the right to be represented at this meeting by a representative of your choice, which is usually one of us, but at times maybe one of our council and ourselves going in on your behalf with you. And you have the right to receive in writing any decision from the board. Now, as Dawn alluded to, and I'm going fairly quickly because otherwise we won't have time for any questions, but there is some statutory protection which is really important, and it's it's very powerful language for us, and we would vociferously defend it in any revision tied to contract, and that is Section 21 of the School Act, which you can go and read at your leisure over the next day or two. But it's Section 21 guarantees that if the board does not intend to renew or intends to dismiss, that there's an offer of a teaching position made to you. That's a contractual right and not something that that is weaker than that. Okay. And as far as severance and working notice, that we'll talk about that at another time.
Okay, thanks, Warren. So general understandings prior to signing, we ask that you read your contract. You'll be provided probably 48 hours in which to go over it. You're entitled to that. You need to go over it with somebody that's in the know. So every association or every chapter, every district, we have members that are on the contract team. And you should try and track down who that is so you can go over it with someone. We ask you to do that because sometimes there's a contract that's issued to new members that is slightly different than those that are already in the workforce. Don't be afraid to ask questions. It's your opportunity at that point in time to ask for some clarifying questions. Some contracts are very wordy. They should be written in a language such that a 12-year-old understands. You have one opportunity before you sign to get clarification on the terms of your contract. It's imperative that you use that. Okay, so that brings us to a close. That was Understand Your Contract 101, very quick. But if there are any things that we touched upon, any questions that you may have, Warren and I are free to do that and more than willing to do that.
All right, thank you to Don and Warren. So if you have questions, please post them in the question box and we will get to them. One question I did have, I will send out the slide deck to all of our participants. Next week, we will post on our YouTube channel a version of this webinar. So for anybody who is not able to join us, a couple things. I'm going to ask Don and Warren, maybe if they could talk about their perspective in district contract processes more recently. Are there specific items that you're seeing? Are you seeing any trends in terms of items that districts are interested in addressing or revising? And I will turn it back to them.
Well, let me begin by saying we rely upon the members in the field to get a hold of us about things that are going on with their contract language. Some things that have been under pressure for a number of years have been long service recognition. It's an unfunded liability, so we've had 19 districts that did have it in, or 19 associations had that language in there. It's under pressure because it's unfunded, so now it's being moved a little bit. We have the term specific. We're finding that there's more and more that are offering a 2-year term or a 3-year term versus offering somebody a continuing contract right off the bat. The evaluation process that people are embarking upon, that is all over the place in the province right now. So we're trying to get some alignment in that area. Now, Warren, you've got a couple others?
Well, there's about 3 things quickly. One is that BCPC, the Employers Association, has spoken with their membership around modernization of contracts, which is fine. You get it, and that means adjusting things to better fit in today's world. However, that modernization, what that means to each of the 60 school districts is a little bit different. So we often have not issues, but things to talk about in one district where they're not really all that interested in it at another, because it's it's okay in one but not the other. And the other two that we've dealt with a bit is language around the right to go before the board, and months of entitlement should there be an agreement to terminate the contract without cause and move into a severance package, which before would have been in the range of 6 to 18 months, and in some cases the proposed changes have been 3 to 12 months. And of course, we spend a lot of time when there are changes like that to be discussed, making sure that our members are properly represented.
So we have another question. Are addendums as secure as the contract itself? Why would we use addendums rather than adding sections to the contract? For example, leave and leave intentions.
Sure. Thanks, Kevin. Addendums or appendices, if they're in with the main contract, our part of your contract, where we have concerns is where it's put into board policy. Now, Warren covered that earlier, that if it's in board policy, board can change that at any time without input from you as a principal or from your association. If it's part of the contract, the language in there that you have guides how it can be removed or applied. Okay, Warren, other thoughts on that?
Yeah, on the cases of leaves, it's a good point. For example, a lot of school districts at the moment don't have any maternity language. Now, a lot of them just follow what it is for the principals. But with it not being in contract, it's open to the whim of the board. The board can change it. On the other hand, if you're a board member, you're also constantly worrying about the cost of leaves and benefits and so on, given the tightness of their budget. And so as they take a look at whether it goes into contract or not, they're also thinking about what if we had to make some sudden adjustments? Would we be able to do that? Would we not be able to do that? So it becomes an item of discussion, and then ultimately some you'll find are in, and some you'll find that you might think should be in are not there yet.
Good point about the maternity. There are only 19 contracts in the province that have maternity clauses in them. Of the others, they make reference to the teachers' collective agreement or employment standards, and we're of the opinion that if it's your contract, the information should be included within the body of your hard copy of your contract without having to go and search out another document for another association or union.
So we have one more question. If you have a July 1st start date, what things should you be looking for considering if you move to a new district with a different start date?
Oh, that's a very good question. Warren and I have dealt with a number of different matters on that. Warren, how about if I take a kick at it first?
Sure.
Most recent one that I'm dealing with is it was a July 1st. And that member in their contract stated that they had to give notice in January. The new district that hired them was an August 1st date. And so for that period of 1 month, they were not paid because July 1st was the cutoff. Their medical, etc., covers for 30 days. So they were covered there and brought it on. But one of the other things you have to be very careful about is that if you start July 1st and the other district starts paying you, or the district that hired you July 1st starts paying you for July and August, and you want to leave mid-year, you're going to find yourself owing the district payback. What I mean by that is they have commenced pay, giving you holiday pay for July and August, and you have not yet earned those days.
It's front-end loaded.
It's all front-end loaded, and you earn those throughout the year. Now, if you had an August 1st date, it's the end of January that you've paid off those dates, and the rest of the year you're accruing your holiday pay.
You know, usually it's not that much of a problem if you go in and talk to them ahead of time and spend some time saying, look, I need to make sure that my family's properly looked after, and you have the discussion. Where you run in, and that's why it's so important to know what's in contract and what's coming your way. So I'll leave it at that for this point, but we're right here if you need help on that. So
one other item,
call us here.
Yeah, one other item that we found is that in contracts, districts that hire you August 1st have language in there that's saying if you're retiring or if you're leaving the district, you do so July 1st. And we're going, wait a minute, that doesn't make sense. You have earned holidays for that month of July. So if the district says, sorry, you've got to have your resignation in by June 30th, the district owes you 3.5 weeks of pay for that month of July because you have earned holidays from January, February, March, April, May, June. You've worked that and you've accrued holidays. So you need to be aware of that. Kevin, any other questions?
That looks like it's our final question. So I want to thank Don and Warren for presenting today. As you can see from the questions, there's a certain level of complexity to this work, which speaks to why we still believe and are continuing to work on the BCPVPA negotiating some provincial items on your behalf. I do want to also give a plug. Tomorrow at 4 o'clock, Jack McNeil from HumanWorks and Wade Repto will be presenting to our members on how to personally support your personal well-being. There's a registration link that was sent out to all of our members last week. We will also send out a reminder on Twitter today and encourage you to sign up for that. So with that, thank you to Don and Warren. I'm going to bring our webinar to a close. Have a good day, everyone.
Thanks, everyone.
Thank you.